Good morning everyone and welcome to this event, Negligence, More Than Slips, Falls and Snails in Bottles, as part of the County Court's special Term 4 VCE Legal Studies events. Before I introduce myself, I would like to start by acknowledging the traditional owners of the land from which I am speaking, the Wurundjeri people of the Kulin Nation. I pay my respects to their elders past and present and emerging leaders. My name is Tiana and I'm the Education Coordinator here at the County Court. I will be moderating this event today. All attendees of this event have their cameras and microphones turned off, but you can pop your questions in the Q&A box at any time if you have them, and we will try to get to as many as possible after the formal discussion. Just as a reminder, please set your name to your school name, and you're not permitted to take any photos or record this event. With that, it is my pleasure to welcome our panel today. Judge Clayton, Judge Fraatz and Judge Manova. Thank you for taking the time to join us. I might pass over to Judge Clayton first for a brief introduction.
Hi, my name's Julie Clayton. I've been a judge in the County Court for about 2.5 years. Before that, I was a judicial registrar in the Supreme Court for about 4 years. And before that, for more than 20 years, I was a solicitor. And my practice areas were mostly personal injury, medical negligence, and in personal injury class actions. In the County Court, I head up the defamation list, and like all of the judges in the common law, do a lot of personal injury work as well, which inevitably involves a lot of consideration about negligence.
Judge Fraatz?
Yes, my name's Andrew Fraatz. I have been a judge for about 18 months now. Before that, I was a barrister for nearly 20 years. I had a general practice in commercial and personal injuries, and in particular in the latter part of my time at the bar in class actions, and a lot of my work involved consideration of claims in negligence, as does my work at the County Court. I'm also the judge in charge of the family property list at the County Court.
And Judge Manova.
Hello, Diana Manova is my name. I was appointed in June this year, so I'm a very recent appointment, a very new judge. I was a barrister for 22 years, practising in crime and in personal injuries. I love being a barrister and I hope to love being a judge of the Common Law Division.
Great. Thank you very much, judges. I think most students here will be familiar with the Donahue and Stevenson snail in the bottle case, which of course established the general principles of duty of care. So on that kind of line of thinking, we might start with Judge Clayton, and perhaps you can start us off today by talking us through a little bit of the elements of a negligence claim.
Well, the elements of the negligence claim, first up, is there a duty of care? And the interesting thing about Donahue and Stevenson was before that case, really the idea had been that cases where something went wrong really had to be founded in contract. And that was a fairly revolutionary type of case. So the first question that you always have to ask yourself is there a duty of care? Let's just say you're driving a car, you're stopped at a traffic light, someone rear ends you. Do they have a duty of care to you? The law would almost inevitably say yes, they do. But what about if you're not driving the car, but you witness the accident, and witnessing the accident causes you to develop a psychiatric condition, post-traumatic stress disorder, for example? Does the driver have a duty in those circumstances? Well, the law might go either way. It might depend on the particular circumstances. And what about if you didn't see the accident, but you came across the scene, people were arguing, you got distracted and you walked into a pole and hit your head, and you suffered an injury in that way? Does the driver of the car who caused the accident owe a duty to you because you suffered an injury indirectly as a consequence? In that situation, the law would have to look at what was reasonably foreseeable and may well find that a duty was not owed. Second question is, has there been a breach of the duty? So, for example, if you've rear-ended someone, is it because you were driving too close? Is it because you weren't paying sufficient attention? And in deciding whether there's been a breach of duty, the court has to look at what is the standard of care. What is a driver of a car in that circumstance expected to do? They might be expected to drive safely, to be aware of their surroundings and to look at the traffic. And finally, did the breach cause the injury? And this is a very important one, and one that's often the topic of a lot of evidence and a lot of discussion in court. What caused the injury? Because Let's just say, going back to our example, you're in the car and you're rear-ended and you get a whiplash injury. Well, it's pretty obvious that it's the cause of the accident caused your injury, and that's fairly straightforward. But what if the next day you suffered a heart attack and you really think that you suffered that heart attack because you were so stressed because of the accident? Might be a bit more difficult to might be a bit more difficult to prove the cause. So that's a really hot topic. So they're the three elements. Was there a breach? Was there a duty of care? Was there a breach of care? And did it cause the injury?
Okay, thank you, Judge. Judge Fraatz, in terms of which court a negligence claim may be heard in, is there a factor that determines that, or perhaps a threshold?
Yeah, well, there's probably a couple of aspects to that. The first one, of course, is the jurisdictional limit of the particular court involved. The Magistrates Court issue claims to the value of up to $100,000, whereas the County Court and Supreme Court have unlimited jurisdiction to hear claims in relation to negligence claims in relation to damages. So, to come back to the example of a car accident, there might be two types of claims there. One for property damage to the repair cost of the vehicle, and secondly, personal injuries. So a smaller claim for personal injuries, for example, which doesn't involve a major injury, some small time off work or something like that, you might issue that in the Magistrates Court. A more serious claim would go to either the county or the Supreme Court. In terms of property damage, again, if you're driving a Mazda 3 or a more standard sort of passenger vehicle, the repair costs unlikely to exceed $100,000, and most of those claims are heard in the Magistrates Court. However, if it was a couple of high-end buses or trucks or something like that, or a vehicle with very expensive cargo, which to the value of over $100,000, well, giddy up here in the County Court or the Supreme Court. The other thing to bear in mind is that the Supreme Court has, and the Federal Court in fact, has exclusive jurisdiction to hear and determine class actions, which you've probably heard something about, if not in the course, more generally in the media, whereby a lead plaintiff brings a claim on behalf or representing sometimes many thousands of other persons who are affected by the same or common questions of law and fact involved. Back to the car accident example, let's say that the manufacturer negligently designed and installed a brake system which catastrophically failed. So whilst that may have impacted on the circumstance of the rear end circumstance, an accident and claims, that is a situation which applies to perhaps thousands of vehicles. But those claims have to be determined in the Supreme Court.
Andrew, when you were at the bar, how did you decide if something was going to come into the County Court or the Supreme Court?
Well, that probably leads into the third sort of discretionary sort of factor, and that would be where you do have a choice. You might look at certain things like when you might be able to get the trial date, as soon as possible, for example, and different courts have different lists and different time frames. The other thing is the level of complexity of the case. If there are very difficult questions of law, if there are very large sums of money, which is going to lend itself to complex expert evidence and managing claims, you might be better off in the Supreme Court too. And also if there's a particular question of law involved, because the Supreme Court can then deliver a ruling which can be used by the lower courts to assist them in determining similar questions.
Great, thank you very much. So Judge Manova, in terms of the relationships that might give rise to a negligence claim, what are some of those relationships, and perhaps what are the most common ones that the court might see?
So what the law requires is where there's a duty to take reasonable care, where the law imposes a duty to take reasonable care, you're going to have a relationship that can give rise to a negligence claim. So we've heard about motor vehicle, for example. Motor vehicle drivers, that's fairly obvious. But what about the case of a user of a motor vehicle, for instance, a passenger who might open their door? Do they have a duty of care to make sure that there's no oncoming vehicle, no cyclist that might be injured? Also employment relationships. If you think about Most Victorians tend to work, adult Victorians, so there's a very, very large contingent of employers and employees in Victoria. Anywhere from the after-school work that some of you students might do at a supermarket or a McDonald's, full-time work, construction labourers, hospitals. The entire society in Victoria is governed by employment, so employment relationships form a very, very substantial part of negligence claims in this court. Also professional services relationships, so you might have solicitor-client, for example, doctor-patient, if you've gone to a physiotherapist, a cosmetician, even a hairdresser. Hairdresser has a duty not to burn your scalp or damage your hair. A doctor has a duty to act responsibly and professionally and with due care and skill and to provide you with information. Solicitor must act also with reasonable care and skill and provide you with relevant advice for your claim. Also contractual relationships, so building contracts, occupier of land to a visitor, so the most common one that you might come across is the owner of a pool having to put a fence around their pool. Even though the owner and every occupant in his house might be able to swim, for instance, the law would impose an obligation to erect a fence so that a child or a person who can't swim doesn't drown in the pool. If the fence hasn't been erected or isn't secure, then that might give rise to a claim for negligence. Manufacturers of goods, also food, motor vehicles, any kind of consumable item has to be safe and fit for purpose and can give rise to a claim for negligence.
Great, thank you very much, Judge. So the County Court has a variety of different lists which all sorts of claims can be heard under. So Judge Clayton, what lists might a negligence claim fall into?
Yep, there's lots of different lists that are set up in both the County Court and the Supreme Court, and they're really set up for case management purposes so that a judge will run the list and know what's all of the sorts of cases that are in the list and can make orders and make sure that they're running efficiently. In particular, the lists that deal with negligence claims are personal injury type lists. So these are workers' compensation. Judge Manova already spoke about that employment relationship. People get injured at work and they make a claim against their employer because they say that something about the workplace was negligent. Transport accident claims, anything arising from the use of a motor vehicle fall into the transport accident area. In the Supreme Court, one of the biggest lists is the institutional liability list, and we've just set up our own institutional liability list, which we expect will also become a very busy list. And very sadly, this is a list for people who were abused or have been abused in institutions. So whether that's a school or a state-run home or a church-run organisation, any sort of institution where there was abuse. Public liability claims, these might be cases where you're walking down the pavement and you fall over and trip over on a tree root that the council haven't kept appropriately trimmed. So there's a public liability list in the Supreme Court. In this court, there's the medical list, medical negligence list. So that's where you say that anyone in the medical profession has negligently caused you an injury. In the Supreme Court, there's also the dust diseases list, which is cases arising out of exposure to particular types of dust, most commonly asbestos, but also increasingly silicon dust from marble countertops and things like that. And professional liability list as well, where, for example, you might say that your solicitor failed to prosecute your action properly on your behalf, or you say that the engineer that you engaged didn't do the plans for your house properly, or the architect in the operation of their professional endeavours, they were negligent. As well as having claims in negligence, you might also find that you've got other sorts of claims, breach of contract, for example, or breach of statutory duty. But that's a bit of an overview of the lists.
Great, thank you, Judge Clayton, and I think there's some great examples that hopefully will help students coming into their exams perhaps identifying in questions when they should be talking about negligence. So Judge Fraatz, now that we've kind of spoken about establishing a claim and all those kind of, or briefly, those case management elements, what are some of the common defences that we see in response to a negligence claim?
So in relation to negligence claims, there's probably three defences I'd immediately identify. The first would be a voluntary assumption of risk. The second would be a statutory defence of plea in proportionate liability. And thirdly, a defence of illegality. So turning firstly then to the voluntary assumption of risk. That's a subjective test, and to establish the defence, the plaintiff must have appreciated and understood the risk. So, returning back to our motor vehicle example, a passenger who steps into a vehicle who understands and appreciates the risk that the driver is intoxicated and incapable of driving the car will have voluntarily assumed the risk of injury if that vehicle happens to crash. The appreciation must be of the risk which actually eventuates, which causes the accident. So that is to say, if one steps into a car and you know that the vehicle doesn't have lights, you're a passenger in the vehicle's involved in an accident, but that accident is not caused by the fact that the vehicle has no lights, then that is not going to be sufficient to establish the defence. Proportionate liability, the Wrongs Act, that's a fairly technical area. The Act provides that it applies to a claim involving concurrent wrongdoers, which in relation to a claim is the person who is one of two or more persons whose acts or omissions caused, independently of each other or jointly, the loss or damage that is the subject of the claim, and then provides that liability of the defendant who is a concurrent wrongdoer in relation to that claim is limited to an amount reflecting that proportion of the loss or damage claim that the court considers just, having regard to the extent of the defendant's responsibility for the loss or damage. Now, what does all that mean? Let's perhaps look at a concrete example. We come back to our class action. There's been a faulty manufacturing and design and installation of a brake component in a vehicle. So if the manufacturer was sued, one of the first things it would do, its lawyers would do, would look at this question as to whether or not there was some other person who has a responsibility for the loss and damage suffered by the class of persons, the plaintiffs. So the manufacturer might join the engineer who designed it and any other person involved in the rollout of that particular brake unit, and liability would therefore be apportioned between those, and each defendant is only liable for that proportion of loss to which it's responsible. Illegality, there's no general principle which disqualifies a person from bringing an action in negligence merely because a person is engaged in an unlawful act. However, there's legislation in most jurisdictions which specify that personal injury damages will not be awarded where a plaintiff is injured in the course of commission of a crime. So, for example, a passenger in a vehicle where the occupants are involved in a joint enterprise of robbing a bank won't have a claim if involved in that circumstance. Now, there's some subtlety to that. I mean, if the evidence, turning back to our car accident example and drunkenness, if the evidence indicates that participants contemplate that a vehicle will be driven carefully, even where drunkenness is involved, the drunk driver might still be liable, because the court in those circumstances, if it's able to, determine the standard of care which is appropriate to be exercised in the circumstances of the case, can say, well, look, we should have done better. So they're the three main issues.
Great, thank you very much, Judge. So I guess moving a little bit away from negligence specifically for a moment, Judge Manova, what is the standard of proof in a civil trial, and who bears that onus of proof?
So the Evidence Act now provides, before that it was the common law, but the Evidence Act now provides that the standard of proof in a civil trial is what's called on the balance of probabilities. So we contrast this with the standard of proof in a criminal trial that everybody might be well familiar with from watching TV crime dramas, and that's beyond reasonable doubt. So that's a much higher standard of proof. The balance of probabilities, if you think about a scale, it might simply be the scales tipping one way. 51% to 49% might be sufficient to make out the case on the balance of probabilities. Who bears the onus? So in our system of law, whether it's a criminal matter or a civil matter, the principle is quite simple. He who accuses must prove. So if a plaintiff comes along to court and says, my employer was negligent, for instance, the plaintiff must prove that the employer was negligent on the balance of probabilities. If the employer wishes to assert that the plaintiff in some way contributed to his own injury, loss or damage, for example, he was contributory negligent, the employer then must prove that aspect of his case or her case, once again on the balance of probabilities. Where there is an allegation of a very serious matter, for example, in a civil case, there may be an allegation that a crime has been committed, or there may be an allegation that very serious conduct has taken place. So in such matters, although the standard of proof is still, because it's a civil case, on the balance of probabilities, there is a further component that the parties must satisfy the court of, that is, the quality of the evidence. And the principle for that is found in a case called Briginshaw and Briginshaw from the High Court from 1938. And in that case, a man brought a proceeding against his wife for divorce in a court, alleging what was then the ground for divorce, adultery. And the trial judge got the test wrong. So the trial judge thought it had to be proven beyond reasonable doubt, and the matter went all the way to the High Court. And the High Court made a number of observations about what has to be proven where serious allegations are made in a civil case. And the High Court said in a serious matter, and in that case adultery was considered a serious matter, the satisfaction of a just and prudent mind cannot be produced by slender and exegesis, which is very small, proofs. The nature of the allegation requires careful weighing of testimony and close examination of the facts and comfortable satisfaction. So the judge or the jury must be comfortably satisfied, based on the evidence, that they've reached the correct and just conclusion, that is, that the matters asserted did occur. The judge or jury simply can't compare probabilities. You can't just say, oh, is it more probable or not? You've got to do something a little bit extra, and that is the judge or jury must form a view that the events in question really did occur. And finally, reasonable satisfaction should not be produced by inexact proofs, indefinite testimony, or indirect inferences. So although the standard is still on the balance of probabilities, where serious allegations are raised, there must be very strong evidence and the fact finder must be comfortably satisfied.
Great, thank you very much, Judge. And I think we'd encourage students to perhaps go and have a bit more of a look at that case. Sounds like a really great example for them to further their understanding.
Can I just add one thing on that, because it happened in a case recently that I dealt with, and it's a good one for students to know. No idea if this would arise, but it's just a slight variation on who bears the onus of proof, and that's in a case of false imprisonment. So if you say that you were falsely imprisoned by somebody, and this might be if the police have arrested you and they had no basis to arrest you and they kept you detained for a period of time, or if, for example, someone accuses you of shoplifting and won't let you out of the office until the police arrive, but in fact haven't been shoplifting, and you say, well, I was falsely imprisoned for that period of time and I'm entitled to damages for the false imprisonment. It's its own tort. The law says that provided that you, as the accuser, can prove that you were in fact detained, the onus of proving that the imprisonment was not false falls on the other side, falls on the defendant. So that's just a little bit of a variation. You only have to prove the fact that you were detained, and then they have to prove that it was lawful.
Great, thank you, Judge. So one thing that we might see pop up in regards to negligence and duty of care is an exclusion clause or a disclaimer. So how might that affect the duty of care, Judge Clayton?
I love exclusion clauses and disclaimers because you see them everywhere. You go off to some activity or bounce or you get a new job and your employer wants you to waive all your rights to ever sue them for anything. And, I say to people, feel free to sign them because they're pretty much meaningless. And what I mean by that is this. They don't affect the duty of care owed. So no party can get you to sign away the fact that they owe you a duty of care. The duty is always to take reasonable care in the circumstances. So signing a waiver or a disclaimer doesn't mean that the service provider can be negligent. If, for example, you sign a form agreeing to take the risks of going bungee jumping and the provider uses an old worn-out bungee rope and it snaps, well, they can't say, oh, well, you said that you'd take the risk, because the risk that there would be a worn-out rope that would snap isn't a risk that you agreed to take. On the other hand, they are valuable and useful things for service providers to get you to sign, where the risk is just an ordinary risk, doesn't arise out of anyone being negligent, just sometimes can happen. And we live in a world where risks occur and eventuate, and sometimes people get injured, and it's not because there's been any negligence. And it
Horse
riding, for example,
Jumping out of an aeroplane, provided they've packed the parachute correctly and everything's been done right. If the wind blows you into bushes and you land on those bushes and that just happens, well, that's just an unfortunate risk. And so in those cases, service providers are well advised to put in those disclaimers, because it shows that they have warned you about those risks and that you have accepted those risks. And you'll remember Judge Fraatz was just talking about that voluntary assumption of risk. If you voluntarily assumed a risk and that risk has eventuated, not because someone was negligent, but just because it was a risk, then you're very unlikely to be able to prove your claim in negligence. So they're useful in those situations. The other sort of situation that you might see them in is that doctor-patient relationship. And that's really, again, it doesn't say, well, the doctors are entitled to be negligent, and if they are negligent, I can't sue. What it says is, I understand that having this procedure involves certain risks. There's a risk that if you have an anaesthetic, you'll have an adverse reaction to the anaesthetic. There's other sorts of risks. Now, the interesting thing about that doctor-patient relationship is that sometimes if a risk eventuates, it wasn't because of any negligence, but you weren't warned about it. The negligence might be the failure to warn. So, and that would be particularly true if it was a non-emergency, non-urgent or non-necessary procedure. So if it's an elective procedure, cosmetic procedure, and someone has not told you about the risks, you've got a greater chance of being able to say, well, if I'd known that there was a risk that this would all go horribly wrong, that's a decision I would have chosen not to go ahead with. I wouldn't have taken that risk, and the negligence is that I wasn't warned. Remember those waivers, those exclusion clauses, they're not going to be able to get rid of the duty that somebody owes. They're not going to mean that someone can be negligent, but they can be evidence that you assumed a risk, and if the risk occurred not through negligence but just because the risk eventuated, then they're useful in those situations.
Great, thank you, Judge. Judge Fraatz, Judge Manova briefly touched on this before, but perhaps you could expand a little bit on contributory negligence and, how does that differ? And I use this a bit tongue-in-cheek from a straightforward negligence claim. Perhaps you can expand on that for us.
Yes, well, contributory negligence applies in a scenario where a plaintiff has established negligence on behalf of a defendant. So that's the first thing. And it involves a reversal of the onus of proof and an allegation by the defendant that the plaintiff, him or herself, failed to take reasonable care for their own safety. Like negligence, the test is objective, and so one disregards any particular idiosyncrasies on the part of the plaintiff. And as always, and again, similar to negligence, the particular circumstances and surrounding factual matters need to be taken into consideration in determining what might be reasonable in the circumstances to expect of a plaintiff. So again, perhaps returning to our examples, we've discussed horse riding. I mean, there's an inherent risk in horse riding. One's warned of the risk, that's if you've signed a waiver. But if the plaintiff is injured by reason of doing something silly, trying to jump a fence or doing something that unnecessarily exposes themselves to a risk of injury, well, that's the type of scenario where the court will be looking very carefully at making a finding of contributory negligence. Other examples might be, I've just heard a case about this very scenario where an elderly lady arose to disembark from a train as it arrived at a station. The train door didn't open. Now, that was caused by the evidence was that it was caused by the negligence of the driver in operating the door release mechanism. But by the time she and a fellow passenger were able to force the door open, because she'd made a determination, the plaintiff, that it was 10 or 11 o'clock at night, she had to get home, she had her shopping, she didn't want to go to the next station and wait in the dark or have to walk back through an industrial area where it was known to be a dangerous and unsafe area, that she was going to get off the train. She was pretty focused on that. But by the time they forced the doors open, the train had just started to move and she stepped out of the train. So the question there is, did she unnecessarily expose herself to the risk of injury by stepping off a moving train? Importantly, in that case, and in any case considering contributory negligence, there's a balancing exercise to be conducted between the negligence of the defendant in the first instance, giving rise to the situation, and as against any negligence or responsibility the plaintiff ought bear in that circumstance. So that's a bit of an overview.
We see it a lot in workers' compensation cases, don't we?
We do.
But very often there'll be a claim by the worker against the employer saying that the workplace was, there was some negligence in the workplace or the system of work, and then there'll be a claim by the employer against the worker saying, well, you contributed because we trained you to do it this way and you did it a different way, or you didn't wear your hard hat or whatever. And in fact, one of the judges in this court just had a jury trial, and the jury decided that the defendant was negligent, but the plaintiff was contributorily negligent, and decided 90% of the damages was caused by the plaintiff's own negligence. Yeah.
Usually, particularly in employment cases, there's a line of authority that establishes that mere inadvertence or inattention in an employment context, particularly in sort of repetitive tasks like process work and so forth, does not or cannot constitute contributory negligence.
Yeah, if you've taken your mind off the ball.
Just briefly, you glance at your watch and your hand goes into an unguarded saw or grinder or something like that. Again, that's the sort of thing that where the courts would be looking to consider whether or not that was a case of mere inadvertence, and that doesn't constitute negligence on behalf of a plaintiff.
Because part of an employer's duty is to consider that it's possible that a worker might be inadvertent.
Yes, or have a momentary lapse of attention.
You're not able to concentrate 100% all of every minute of every day that you're at work, and you might take your mind off the ball for a moment, and if you can still cause yourself a serious injury in that circumstance, well, it's probably not a safe system of work.
It just highlights, I think, the attention that the courts give to the particular facts and circumstances of where somebody is injured or a negligence claim arises.
Great. Thank you, judges, and I think for problem questions particularly, that's some really good scenarios and points to look out for students coming into exams when they get a factual scenario. And speaking of exams, this topic has featured on past exams, so it's probably a good one to pay close attention to. But Judge Manova, what is the advocate's immunities defence?
Okay, so if we start from the position that lawyers are, like all professional people, owe a duty of care to take reasonable care to exercise due skill and ability in delivering their service to their client. So if you go to a solicitor, your expectation will be that the solicitor will exercise due care and skill that they'll have read the law properly, and that they will advise you on your particular case in a competent way. So that's the starting point. The advocate's immunity defence is, if you like, an exception, a form of exception to that general proposition. Where an advocate in a civil case, it doesn't matter whether it's a barrister or a solicitor appearing in court, it's somebody advocating in court, has done work in court or work out of court which is connected with the conduct of the case in court. And importantly, and the conduct, that is the advocate's conduct, generates or affects the resolution of the case by the court. So there's a number of elements that must be satisfied before the defence will apply. Where those elements are satisfied, the advocate has a defence at law to a claim that, but for his or her negligence or incompetence, there would have been a different outcome. So, but for his or her negligence, there would have been a different outcome. That might be the claim if the defence didn't exist. So, if a party loses a case, you go along to court and you lose your case, you can't sue your barrister or the lawyer acting for you in court and use as a basis for your claim that but for your lawyer's conduct, you would have won the case. And there's a reason for this, and it's called a public policy reason. So you might have been taught something about public policy in the course of your studies. Public policy reasons in law provide a basis for a certain view or interpretation of legal principles. For example, the most basic example, we have contracts that regulate how we conduct commerce in our society, and the public policy reason behind upholding contracts is to ensure that people can go ahead with commercial agreements and that ensures commerce in our society. The public policy reason behind the advocate's immunity defence is that we attach a strong value to the need for certainty and finality of decisions made by judges. Now, you can just imagine what might happen if this defence didn't exist. Every time somebody lost a case, they would come along and say, it's my lawyer's fault. And then what you'd need to do in order to determine, well, is it really the lawyer's fault or not? Would the case have been any different had the lawyer made different submissions, led different evidence, asked different questions, or whatever the allegations might be? The only way you could resolve that is to relitigate.
Run the case again.
Yes, relitigate the entire case. So the system would grind to a halt.
And then you could say, in the appeal, it was my lawyer's fault.
That's exactly right. And it would go on ad infinitum. So lack of confidence in the legal system, delays, uncertainty and inability of parties to organise their affairs consequent on court orders are some of the reasons why it's not a good idea to enable people to avail themselves of such a claim. And finally, for the defence to apply, there must be a connection. So it's not always the case that everything a lawyer does in court is immune from a negligence claim, but there must be a connection between the advocate's work in court and the decision made by the judge. The conduct of the advocate must be such as to contribute to the judicial determination. So it's not open slather, it's very focused.
Great, thank you, Judge. I'll just make a note to all our students and teachers watching. Please, if you do have any questions, pop them into the chat and we'll be happy to answer them. And so we know your exams are coming up, so there might be something we've touched on that you want to expand a little bit more, so please feel free to do so. But while you might be thinking of those, I'll just carry on with a few more questions for the panel. So, Judge Clayton, what remedies might be available to parties in the instance of a negligence claim? Now that we've kind of gone through our elements and our defences, what are the remedies that we are looking at?
The remedy is basically money. And much as many of my clients would come to me and say, look, I just want to make sure this never happens again, or I just want that person who was responsible for this injury that has occurred to me to be held accountable, or I would like an apology. That's not what the law of negligence can provide or aims to provide. What the law says is that a person who can prove all of those elements that we've talked about of negligence is entitled to compensation, money, that would put them back into the position that they would have been in if they hadn't had the injury. Now, that can be quite straightforward when you're looking at purely economic sorts of loss. So you can judge Fraatz's example of where your car has got crashed into by someone else. You haven't been injured. Your car's been damaged. It was the negligence of the other driver. You can replace your car. You can fix your car. The amount that's worth, pretty straightforward. But what sort of money compensates you for an injury? And what I would always say to my clients is there is no amount of money that can compensate you for your injury. If I said to somebody, I will give you $5 million and as a result of that you'll be in a wheelchair for the rest of your life, I don't know anyone who would take that deal. There's just no real way. But it's all we've got. And there's thresholds on the amount of damages that you can receive. It's never as high as you think that it will be. You hear about multi-million-dollar claims, but most of those claims are made up of loss of wages and costs of care. The actual amount that you get for your pain and suffering is pretty modest. It's about $600,000 is the highest amount that you can get for pain and suffering. And that doesn't mean that everyone gets $600,000. That means that the most serious, the most severe, the worst injuries would receive that. So money is what you can get. Pain and suffering, so that's everything that you can think of, the hurt, the loss of enjoyment of your life, the loss of amenity, pecuniary loss, silly legal word for just economic loss, so that might be the damage to your car, the loss of wages while you took time off work to recover, or you might have been left with a permanent injury that impacts the way that you can work in the future and you're entitled to the future losses that you will accrue from not being able to do the same work that you used to do or being limited to only being able to work part-time, something like that. You can also claim costs in certain circumstances, and I won't go into the detail of it, but in certain sorts of cases you can claim the costs of gratuitous care. So that's care that other people provide to you. If you're injured and you have to take some time off work and your mum is looking after you and doing all sorts of care for you that she wouldn't normally provide, you might be able to claim the cost that she's of the care that she's providing for free, because if you didn't have your mum providing for free, you might have to engage, a local nurse, for example, to come and change your beds and do all of the sorts of things that your mum's doing for you, and also the sort of costs of things that you are providing to other people for free, but you can't because of your injury, so you can sometimes claim those sorts of things as well. Two other sorts of damages might be available: aggravated damages and exemplary damages. Aggravated damages, and when we talk about damages, it sounds very similar to damage, but actually it just means money or compensation. These are all interchangeable words. Aggravated damages is where the law recognises that you've had an injury and it's been aggravated in some way by the conduct of the defendant. So the defendant has made it worse by, I keep on thinking, because I'm a defamation judge, of defamation cases where you've proven that they've defamed you, but the damage that they've done is aggravated by the fact that they said it was all true, that their defence in court was that it was all true, and that sort of, made it worse. Exemplary damages are also called punitive damages, and as that word suggests, they're designed to punish. So the ordinary principle of compensatory damages is to put that plaintiff or that injured party back in the position that they would have been if the tort hadn't happened. But exemplary or punitive damages have a different purpose, and they are designed to punish the wrongdoer. It's a way of society saying, we think that what you did was so bad that as well as making you pay money to compensate, we're going to make you pay extra money, and it goes to the plaintiff, extra money to punish you for your bad behaviour. It's a sort of a civil way of trying to right a wrong where that conduct doesn't necessarily involve criminal offences so that society would sanction it in a criminal way. It's a different mechanism for society, I suppose, to express its disapproval.
Great, thank you, Judge. Just conscious of time, so we might move on to a couple of our live questions coming through. So we have one from Ringwood Secondary College, and they would like to know, how do you approach a case that might involve multiple parties, or potentially a case that has a shared liability between certain parties as well? So I might open that to all of you judges.
One of the things we
almost
just
always
discussed.
have those cases, don't we?
Yeah, that's right. It's very common. You know, for example, in a personal injuries context, you might have a tradesman or worker injured on site. Now, that worker will be owed duties by the employer. He may be owed duties by the occupier. And he may be owed duties by a person with control over an aspect of his duties or part of the site.
Someone who erected scaffolding, for instance, if he's fallen off scaffolding.
Correct. A good example. So from the judge's perspective, I suppose for my part, one would want the pleading, so that's the particular, each party's claim, the way they articulate their claim. It's called a dance by some between the parties. But that needs to clearly or crystallise the parties' respective positions about what the duties owed by each were, any defences and any cross claims as to the apportioning responsibility or contribution to the plaintiff's damages. So it's a matter of ascertaining firstly the claims, how they're put, and then from a judge management perspective is, well, what evidence are we going to allow in respect of each of those matters?
Sometimes when you're a plaintiff, you might not know all of the people who might be responsible for the thing that's happened to you. You're employed by your employer. I'm just going with the employment example, for example, and you say, well, I went to work that day and this terrible thing happened. But the employer knows that the terrible thing happened because, they hired someone to fix that machine and the person who was hired didn't fix the machine properly. So they join that other party, and then that other party might say, oh, well, we
what about the manufacturer?
Machine. Yeah, what about the manufacturer? Well, we fixed the machine correctly, but we were given a dud part by Bob down the road. We're joining Bob down the road. And sometimes you can get this sort of series of people, and in some instances, the plaintiff might say, yeah, well, actually, they're all responsible for me. I'm going to sue all of them. I'm going to join them all. And other times the plaintiff might say, well, I don't care about all of those people. I was employed by my employer. They were negligent. They can worry about all of that. There's lots of sort of different ways that it might go. I had a case recently, quite interesting, where a fellow was going to fix a sign on a road. He was subcontracted by Vic Roads to do that. So his employer wasn't Vic Roads. It was a different organisation. He went to fix the sign on the road and he noticed that there was a dog on the road. He was a bit worried about this dog getting hit, so he sort of coaxed the dog back onto a nearby property. Turned out that the dog was actually a guard dog for an adjacent property. The dog attacked him. So there we had an occupier of the land, we had an occupier of the other land, we had the dog owner, we had his employer, we had Vic Roads, all sorts of different people that were involved. It ended up in the end of it all, it all settled, and what was left was the insurance contract between the occupier of the land and the insurer, who said wasn't our fault. So that's what we got left with having to decide.
Great, thank you, judges. And I think you kind of touched on a little bit for my next question, which comes from Haileybury College. And they're just interested in perhaps any particularly interesting cases that you worked on, I think involving negligence, but perhaps if there's anything else particularly interesting you can think of, maybe as a barrister or as a judge. So Judge Fraatz or Judge Manova, perhaps if you have any stories for us.
Yeah, I've given an example of the lady who was injured disembarking from a train. I found at the bar, some of the interesting cases in which I was involved were circumstances where electricity providers or utilities started bushfires, and I found them fascinating because I think one of the great privileges of being a barrister or solicitor for that matter is that you don't need to know everything about everything, but in the circumstances of your case, you need to know a narrow area of engineering or electricity provision or whatever the issue might be, and you need to know that narrow area deeply. And I found that process very, very interesting.
I think all cases are interesting. You have to focus on a very, very narrow issue, and often it involves dealing with people. So the most interesting part of either being a barrister or really a judge is the evidence that comes from people and their individual life experience. And I find people and their stories absolutely fascinating.
I agree with it.
When I was a very junior solicitor, I had a case. I was just a very junior solicitor on this big class action, and it all involved people who got hepatitis A from eating contaminated oysters. And so I had to spend a lot of time flying up to the northern New South Wales lakes where the oysters had been grown, and seeing where the oysters were grown, and we were trying to work out how the hepatitis A had got into the waterway. We're looking at septic tank systems and sewage management facilities, because that's basically how the hepatitis A gets into the water. And yeah, as Judge Fraatz was saying, I became a little expert for a moment there about oysters and their filter feeding habits and the ways that sewage gets into waterways.
Great, thank you, judges. Yes, I imagine, particularly as barristers and I guess as judges listening to all the evidence as well, you do kind of become an expert on some quite niche topics after a period of time.
And in fact, you have to, in order to properly run a case, you must become an expert in the subject matter of the case. And that includes every aspect of your case. You have to be able to lead expert evidence from doctors, from engineers, from architects. In crime, you will have to know about DNA, you'll have to know about blood spatter, you'll have to know about gunshot residue, fingerprints. So every single aspect of your case, regardless of the area that you practice in, you have to become a little mini expert for the purposes of that case. And that's a fascinating part of the practice of law and very unusual to other professions. Most doctors only have to know medicine, whereas lawyers have to know a very, very vast range of subjects over and above the law. And that is what is so cool about being a lawyer.
Great, thank you, judges. Just conscious of time, so I might just ask you if you have any kind of final comments or advice for students, or just anything you wanted to say before we kind of head into wrapping up our session. So I'll just open that up, but yeah, any final comments from you?
Well, I'd encourage everyone who is interested in the law to pursue it. It is a very, very rewarding career. It's fascinating, and it gives you so many opportunities for such interesting work, not just being a lawyer, but a range of other jobs are open to people who do law degrees, but there's nothing better, I think, than being a lawyer.
Okay, thank you.
Yeah, and there's a lot of opportunities at this court and others for young lawyers, either having just completed or about to complete their degrees, to come and be an associate, so assist judges. And I think despite the widely held views, that's a really stimulating and wonderful job. You know, you're paid to learn in a sense, and you're exposed to all of the things that we've been discussing. So again, if you have the interest, that's it's probably a stepping stone for wherever you might land in the law, but it's a good option.
One thing I'd say is come to court. Supreme Court, County Court, Magistrates Court, they're all open. You can walk into any court any time and watch what's going on. And it's like a bit of live theatre. Now, you might get an unfortunately dull, 2-hour submission by counsel on a very technical legal point of view, but you might see really fascinating evidence from a witness in a box. You might look at any number of sorts of trials, from the grisliest crime to the, most technical commercial. But they're open. You don't need to worry. You don't need to feel that you're not allowed to be in there. Walk into the court, bow to the judge, take a seat and just watch.
Turn your mobile phone on.
Turn your mobile phone on. If you're not interested, walk out and go into the next court and see what's on there.
Yes.
I cannot encourage you enough. Most people don't go to court, even people who are studying law, never step foot in a court until they actually practice it. And it's just such a, I think, interesting way to pass a couple of hours. So come to court.
Yeah.
Thank you very much, judges. Thank you to Judge Clayton, Judge Fraatz, Judge Manova for your time today. I know you're very busy. people, so thank you very much for giving up some time to speak with us all. I'm sure students are very appreciative of your answers, your insights, and some advice to them as well for those who might be in Year 12 and heading into studying law at university, or for those just kind of starting to think about where their interests might lie. So thank you very much for that. Students and teachers, thank you very much for joining us today. We really appreciate your questions and your time, and your participation in this event. And we wish you all the very best for Year 12s heading into your final school exams, and Year 11s heading into, I guess, exams that will prepare you for next year. So best of luck with that. If you haven't already, please feel free to visit our website and check out our suite of free educational resources. We have quite a few really interesting fact sheets and case studies, and some videos on there for you to watch if you are interested. We will be sending a recording of this video out once that is set up and ready to go, so keep an eye out on that and you can revisit the wonderful answers and insights that we've had today. And at the end of this Zoom, there will be a very short survey, so we really encourage you to complete that if you can, to help us learn how we can best create resources for you and continue to provide useful information. So that will be concluding our event. Judges, once again, thank you very, very much for giving up your time to speak to us. And thank you everyone for coming along. We hope you have a really lovely day. Thank you.